Families and the law. Property division. Family law in Alberta is complicated, but learning about the law that applies to your situation is a very good first step. This video is one in a series that talks about different parts of family law in Alberta. This video focuses on dividing property at the end of a relationship. Are you and your partner or spouse separated? If yes, you might be trying to figure out who gets what property. This could be the house and the car, as well as bank accounts, kitchen appliances, tools, furniture, savings, and more. There are a lot of things to think about. Who owns the property? How does it make sense to divide the property? What is fair? Are there tax consequences to dividing property? Do you already have an agreement saying how you will divide your property? Are you married or not? If you and your partner or spouse already have an agreement about dividing property, you should read it. A prenuptial agreement is an agreement signed by a couple before they get married. A cohabitation agreement is an agreement signed by an unmarried couple just before or after they move in together. A separation agreement is an agreement signed by a couple after they separate. If you and your partner or spouse do not already have an agreement, you can make one. A do-it-yourself agreement can save you time and money and gives you more control over the decisions you need to make, though it is a good idea to consult a lawyer to make sure your agreement is fair and enforceable by the court. The court will not enforce a written agreement about dividing property unless you have met with a lawyer and signed a certificate saying you understand the agreement and are aware of rights you might be giving up and are signing the agreement voluntarily. You can also get help from a professional to make an agreement. You could work with a mediator, a neutral person who helps you work together to come up with an agreement that works for everyone. You could work with an arbitrator, a person the parties appoint to make decisions instead of a judge. The arbitrator will make decisions about dividing your property. Then there's mediation arbitration, where a mediator is given the power to make a binding decision if you cannot reach an agreement. Finally, there are collaborative processes, a type of negotiation where both parties have their own lawyers but work together to find solutions without going to court. If you cannot come to an agreement, only then will you have to go to court. You should know what the law says about dividing property, even if you are making your own agreement or are getting help from a professional, or even if you are going to court. The Family Property Act is an Alberta law that sets out how to divide family property when a marriage or adult interdependent relationship ends in Alberta. An adult interdependent relationship is a type of relationship for unmarried people. The Adult Interdependent Relationship Act is an Alberta law that describes this type of relationship. Family property is the property you come to own during a marriage or adult interdependent relationship. It includes assets and debts. Assets include real estate, vehicles, bank accounts, investments, some insurance policies, pensions, business interests, valuable collections, and furniture. Debts can include mortgages, lines of credit, car loans or other loans, overdrafts, credit card balances, and future lease payments. The Family Property Act divides property into 3 groups. The first group is exempt property. property that one person gets to keep and the other person has no rights in. Exempt property includes property a person owned before entering into an adult interdependent relationship or getting married. It also includes gifts from someone else, not your partner or spouse. It includes inheritances, money received in court settlements, or from non-property insurance policies. There are rules about claiming exempt property. You must still own the property or be able to trace the value of it. For example, you inherited $10,000 and purchased the painting hanging in the living room for $10,000. The value of the original property, the inheritance, can be traced to the painting. If instead you used the $10,000 to go on a vacation or to pay bills, the value of the original property, the inheritance, cannot be traced. The second group of property under the Family Property Act is that which you and your spouse or partner will divide unequally based upon what is fair. This depends on many things, such as each partner's roles and contributions, how long you've been together, your incomes, etc. Property that is to be divided unequally includes increases in the value of exempt property. For example, say you inherited a cottage worth $100,000. It's now worth $120,000. The increase of $20,000 is divided based upon what is fair. It also includes property bought using income from exempt property. For example, you inherited a cottage and rented it out during your relationship. The cottage is exempt because it is an inheritance, but if you bought things with the rental income, that property must be divided somehow. Property that you buy or get after separating and gifts from one partner to the other are also included in this category of property that can be divided unequally based on what is fair. The third group of property is everything else. The law says that you and your partner should divide this type of property equally unless it would be unfair to do so. Are you worried that your spouse or partner will sell or use property without you knowing? If so, there are ways that you can protect the property to make sure it is still available to be divided. You can cancel credit cards or change PIN numbers on your cards. You can talk to your bank about your joint accounts and more. The Family Property Act does not apply to everyone. It does not apply to you if you are not married, or you are not in an adult interdependent relationship, or you were in an adult interdependent relationship but separated before January 1st, 2020. If the Family Property Act does not apply to you, there is no specific written law about dividing property. There is no written law that assumes you should divide your property equally. So, how can you divide your property? If you have an agreement, divide your property according to the agreement. If you and your partner bought the property together, usually you divide it equally between you. This is called jointly owned property. If only one of you is the registered owner, that person keeps the property. But sometimes it would not be fair to let one person keep all the property. What if the other person has contributed to the property in a non-financial way? For example, if one person stayed home with the children while the other person worked and provided for the family, the person who made the contribution can ask a judge to divide the property based upon what is fair. This is called a claim for unjust enrichment. Unjust enrichment is when someone benefits financially at the expense of someone else without a legally acceptable reason. For more information on this topic, Visit cplea.ca/family.